Assalamualaikum warahmatullahi wabarakatuh. So today our group will be present to all of you about RUJU in perspective of Islam and Islamic Family Law Federal Territories Akta 1984 bagi subjek Family Law SYI 31702 under Dr. TENGKU FATIMAH MULIANA binti TENGKU MUDA. This is 7 subtopic that we will present today. Saya Nur AQILAH binti Muhammad KHAZI 056659. Pada hari ini saya akan memulakan pembintangan saya mengenai introduction. Seperti yang kita sedia maklum, setiap pasangan suami isteri menginginkan perkahwinan bahagia dan bebas dari sebarang masalah. Walau bagaimanapun, setiap hubungan tidak akan lari daripada sebarang masalah dan salah faham. Sehingga kan ada di antara mereka terpaksa memilih penceraian dalam hubungan kerana tidak mampu menangani masalah yang dihadapi itu bersama. Bagaimanapun, ada di antara mereka yang telah bercerai memilih untuk memberikan peluang kedua dalam perhubungan mereka melalui kaedah rujuk. Dalam Undang-Undang Keluarga Islam, rujuk ini bukanlah satu perkara yang luar biasa. Ianya telah diamalkan sejak zaman Nabi Muhammad SAW lagi. Rujuk dalam perspektif Islam bermaksud kembali atau pulangnya seorang isteri yang telah diceraikan oleh suaminya kepada akad pernikahan terdahulu mengikut hukum syarak. Keadaan ini berlaku apabila seseorang wanita itu diceraikan oleh suaminya melalui talak rajai dan suaminya merujuknya kembali semasa dia masih berada di dalam tempoh iddah. Walau bagaimanapun, jika penceraian antara mereka ini adalah melalui talak tiga, mereka tidak boleh rujuk melainkan isteri yang diceraikannya itu berkahwin dengan lelaki lain, kemudian bercerai dengan suami barunya dan melepasi tempoh iddahnya. Secara umumnya, hukum rujuk ni adalah harus, namun hukum harus tu dia boleh berubah menjadi wajib, boleh berubah menjadi sunat, makruh dan haram mengikut keadaan. Lafaz rujuk ni dia boleh dibahagikan kepada dua jenis, iaitu lafaz soreh dan juga lafaz kinayah. Lafaz soreh ni bermaksud lafaz yang benar atau jelas. Dalam arti kata lain, suami ni dia mengucapkan kepada isterinya dengan menggunakan istilah yang jelas dan ringkas, di mana istilah tu hanya membawa kepada maksud rujuk. Contohnya, saya rujuk awak balik. Yang kedua, lafaz kinayah. Lafaz kinayah ni ialah lafaz yang menggunakan kata-kata yang sama, kata-kata yang tidak langsung, di mana kata-kata tersebut memiliki lebih daripada dua maksud. Rukun yang pertama bagi rujuk ni ialah suami yang merujuk isteri. Syarat bagi suami, dia mestilah seorang yang mukallaf, iaitu waras dan baligh. Ini kerana kalau rujuk tu dari seorang suami yang gila maupun kanak-kanak, rujuk tadi tidak sah. Syarat kedua bagi suami, dia melakukan rujuk tu dengan pilihannya sendiri. Bukannya dia dipaksa maupun dia terpaksa melakukan rujuk tu. Syarat ketiga bagi suami ialah suami tu mestilah seorang Muslim dan bukannya murtad. Rukun kedua pula, isteri yang akan dirujuk. Isteri yang akan dirujuk itu mestilah isteri yang diceraikan dengan talak rajai dan pernah disetubuhi dan suaminya merujuknya ketika isterinya masih berada di dalam tempoh iddah. Dan yang terakhir bagi rukun rujuk ialah sirah dan lafaz rujuk. Syarat bagi sirah dan lafaz rujuk ni, dia ada dua pendapat, iaitu pendapat Syafi'i dengan pendapat majoriti ulama. Pendapat Syafi'i, rujuknya mestilah dari seseorang yang boleh bercakap, sama ada dia bercakap dengan menggunakan lafaz soreh maupun lafaz kinayah. Pendapat kedua iaitu pendapat majoriti ulama, sesuatu rujuk tu dia akan diterima sama ada dengan perkataan maupun perbuatan, termasuklah perbuatan berkhalwat.
My name is SITI SHULAYAIHA binti MANAP, metric number 055839. So, we will continue to the Sharia framework on rujuk. As to point out this rujuk in Islamic perspective, there are few groups of view that can be depend based on any matters regarding to rujuk. These groups of views are divided into three groups, which is the view from Shafi'i school, Hanafi school, and the Muslim jurists. Okay, first, from the Shafi'i school view, rujuk can be effective with a valid offer and acceptance, and explicit intention to rujuk is required in order to legalize sexual relationship between the husband and the wife. Meanwhile, from the Hanafi school view, rujuk is valid only by having a sexual intercourse, even though it is with or without the intention. And lastly, from the Muslim jurist view, the consent of the divorced wife is not required to make the rujuk effective in the absence of any strong resistance from the wife, such as the reason of the divorce is due to the wife fault itself.
Okay, next, I am NURUL binti AZLAN, metric number 056438. I will continue about the statutory law on rujuk in Islamic Family Law, Federal Territories Act 1984. Section 51, Resumption of Conjugal Relationship or rujuk, iaitu Section 51, menyambung semula hubungan suami isteri ataupun rujuk. Section 51.1, section ini adalah berkenaan dengan perceraian yang boleh dibatalkan itu boleh dilakukan dalam perceraian talak 1 dan 2, sebelum selesainya tempoh iddah dan persefahaman semula boleh dilakukan oleh pasangan itu sewaktu tempoh tersebut. Seksyen 51.2 pula menerangkan jika selepas rujuk, setelah mereka tinggal bersama di satu tempat kediaman, Pihak-pihak terlibat mestilah melakukan fakta berkenaan kediaman mereka dan perkara-perkara lain yang berkaitan dalam masa 7 hari kepada pendaftar bagi karya masjid di mana mereka tinggal. Seterusnya, Seksyen 51.3, Seksyen 51.4 dan Seksyen 51.5 menerangkan berkenaan dengan prosedur yang perlu dilakukan dalam proses rujuk. Seksyen 51.6, Seksyen 51.7, Seksyen 51.8 dan juga Seksyen 51.9 pula adalah berkenaan dengan situasi-situasi yang berlaku dan cara penyelesaiannya dalam proses rujuk itu sendiri. Contohnya, Seksyen 51.7. Jika berlakunya perceraian boleh ditarik balik tanpa pengetahuan isteri, suami tidak boleh meminta isterinya untuk tinggal semula dengannya tanpa mendedahkan kepadanya hakikat perceraian itu. Seterusnya, situasi-situasi lain boleh dirujuk dalam Seksyen 51.6, 51.8 dan juga 51.9.
My name is Syahirah binti AHMAD Azwaq, matric number 055915. Next, we go to legal issues on rujuk. There are 3 cases we refer about the rujuk matter. First case is Siti Hawa Muhammad versus Muhammad Rizwan. The husband had divorced in wife on August 27, 1989 and want to rujuk back 2 weeks after the divorce on August 27 at the same years. The wife have refused to rujuk with her husband, but the court had decided that the rujuk is valid, as the wife concern is not necessary for the validity of rujuk. The wife appealed. The appeal committee literally confirmed the rujuk, but subsequently referred the matter to the reconciliatory and Islam. In this situation, where the wife refused to rujuk without the reasonable excuses or with reasonable excuses, the court must refer this matter to the reconciliatory and Islam for adjudication or for get a solution. Okay, in the second case, Noyati Tasrik versus Hamid Tikmat. Both parties were married in May 1977 and on November 1988, the husband was applied for divorce before the Commissioner for Oath, Civil High Court, and the divorce was registered in Federal Territory but registered as a divorce pronounced outside the court. Both parties were living separately since February 1988, but on March 17, the husband had stated that he had referred his wife back. He rujuk his wife back. Rujuk cannot be registered due to the overlap information on the original date of rujuk, and the husband appealed to the Combat Syariah Court to confirm the rujuk. The court has confirmed that the rujuk is valid and is sued in order to be registered. The wife appealed on the ground the husband failed to produce 2 witnesses and there was ambiguity on the actual date of the rujuk. Since the wife did not agree to the rujuk, the court should refer this matter to the reconciliatory committee for further proceeding and the earlier decision was set aside. Okay, the last case is Abdullah bin Sulong versus Azwaq binti Ahwang. Both parties were married on August 26, 1980 and divorced on April 7, 1995. They divorced at their matrimonial home in Terengganu due to financial problem. April 1995, the plaintiff pronounced rujuk in front of the defendant and her parents. They go to Syariah Court in June 1995 to confirm the divorce and the validity of their rujuk. In this case, the court affirmed the validity of both divorce and rujuk. So in this case, there was no issue about rujuk and the rujuk is valid.
We will continue to the next point, which is the student view on rujuk. Based on what we had learned about rujuk through kitab, the ulama views, the research on our article related to rujuk cases and more, it can be understood how important this rujuk in the stage of marriage, as it should be clearly known and understood by every couple of married. As what has been stated in subtopic legal issue on rujuk, we can observe that most of the issue that had brought up to the judgment are regarding to the confusion of the married couple, either the rujuk was valid or invalid. Therefore, in these rujuk cases, the main point that we should clearly understood as the law student is the third commandment of rujuk, which is the sirah or the pronounce of rujuk. Through the views of a few school of ulama that has point out in subtopic Sharia framework on rujuk, it can be divided into 2 different views regarding to the sirah. The Shafi'i school stand on their view that sirah must be pronounced by the husband either in outwardly or figuratively in order to valid the rujuk. Meanwhile, the other school of ulama, which is the Hanafi school, stand on their view that by having sexual intercourse with an intention to rujuk between the husband and the wife in iddah period are also interpreted as the sirah. So, after put a deep thought based on these 2 views, we stand to the Shafi'i school view as their view on rujuk give more consideration to the future of the married couple and their child. And also, the view of Shafi'i school is practically respecting the right of the divorced wife to autonomously decide what would be the best for her. And by staying to this mazhab for rujuk cases, the married couple can avoid the illegitimate child cases of their own child and avoid wrongdoing that can lead to sin.
As a conclusion, there are 2, which is the purpose of rujuk and the wisdom of rujuk. The purpose of rujuk. Number 1, to give the opportunity to the ex-husband and ex-wife to get back together, iaitu memberi peluang kepada bekas suami dan bekas isteri kembali bersama dan menjalin hubungan seperti mana hubungan suami dan isteri yang sah. Number 2, to be able to calm the soul and to heal the hearts of every couple, iaitu memberikan ketenangan jiwa dan mengubat hati mereka yang pernah berpisah. Number 3, to restore the purpose of the marriage itself, iaitu mengembalikan tujuan utama perkahwinan itu sendiri, yang mana untuk melahirkan zuriat yang soleh dan solehah. Seterusnya, the wisdom of rujuk, iaitu hikmah kepada rujuk itu sendiri. To be able to avoid the wrath of God against the couple. Seperti mana yang diketahui, Allah Subhanahu Wa Taala sangat murka terhadap pasangan yang melafazkan perceraian. Number 2, to repent and regret the mistakes he or she has made in the past. Untuk memberi peluang kepada pasangan itu bertaubat terhadap kesilapan-kesilapan yang telah mereka lakukan pada masa lalu. And the last, to keep the family institution from splitting up and guarantee a bright future for their children, iaitu untuk memastikan keluarga daripada berpisah dan memastikan masa depan yang cerah buat anak-anak mereka. Kesimpulannya, Allah Subhanahu Wa Taala telah memberikan jalan dan cara yang terbaik buat pasangan, iaitu rujuk, untuk membina keluarga sakinah warahmah. Wallahu a'lam.